Good morning. An important concept, or rather two important concepts that we need to think about in terms of legal ethics are confidentiality and privilege. Now, many people believe that they are synonymous or identical. They have a lot of commonality, there's some overlap, but there are clear and important differences that we must understand if we're going to work in the legal field. So this presentation will help to highlight those differences. Now, this chart really does a nice job of breaking it down piece by piece. So we'll take each topic, each row one at a time and help us to understand and draw differences between confidentiality and privilege. Both are designed to help us to protect the client's information, but it covers different things and in different ways. So the first talks about the origin of our responsibility. So the duty of confidentiality is a duty, an ethical duty. That's why we would look either to the ABA model rules as a general source, or if we're practicing in a particular jurisdiction, then the Code of Professional Conduct for our state. Those would be the sources that we would look at to look at the ethical duty of confidentiality. Whereas with attorney-client privilege, it is a rule of evidence. So that would mean which court system are we in, federal or state? Each will have its own rules of evidence. They are all fairly similar in regard to the attorney-client privilege, but again, we would look to that source for the details, and it also impacts some of the other analysis down below. In the second row, it also covers different information. As we can see with the duty of confidentiality, it covers everything, both public and private information, regardless of where the client got it. They give it to us. We have an ethical obligation to keep that secret. On the other hand, the privilege only covers private information that they've given to us in seeking counsel or representation. So we need to look to what information is being given. Can we claim the privilege? It will depend upon those details. In a related matter, the next row down highlights again where the information is coming from. So for the duty of confidentiality, it applies to all relevant information, where it came from, what sources, that doesn't matter. The client gave us information that they personally accumulated over the years, just known only to themselves. They also conducted some outside research on a particular topic, getting information from third-party sources. Confidentiality covers everything. With regard to privilege, those third-party sources, if it's known to other parties, it's not privileged. Only the private information from the client, known only to the client, will be covered. In terms of disclosure, confidentiality prevents us from disclosing their information anytime, anywhere, though there are some exceptions, and we'll look at them in a moment. But generally speaking, it is a pretty clear and absolute duty, again, barring the exceptions that we'll talk about in a moment. In terms of the attorney-client privilege, because it's a rule of evidence, we're looking at a judicial process. There must be litigation involved in order for the attorney-client privilege to be invoked. So there has to be litigation, and generally we are being compelled. The legal team is being compelled to disclose information, generally under oath. That would be in a hearing, that would be in a deposition, or in discovery requests. And that's where we would use the attorney-client privilege to prevent disclosure of that information within a judicial process. Finally, duty of confidentiality is not waived upon disclosure. Something is accidentally given to a third party or some other individual. Our ethical obligation maintains. It is always going to be present, regardless of if there has been some disclosure by anybody. Our ethical duty continues. However, as I said it just a moment ago, if under certain circumstances we can share confidential information that the client has given to us. The first bulleted item in that final row, the client can give us a waiver. The client can authorize us to share confidential information with others, and then we're okay. If the client is planning to commit some type of crime, more importantly, a crime that would involve substantial bodily harm or death, or some type of fraud, then again, the attorney can also disclose confidential information to the extent necessary to prevent that from happening. Note, future crime, not past crimes. If the attorney needs to defend her or himself in terms of a malpractice suit, then again, uh, to the extent needed to protect themselves in the litigation, they can share information that might be deemed as confidential in order to defend against that claim. If you want more details, you can look either at Model Rule 1.6 of the ABA Model Rules or your particular state's rules of professional responsibility dealing with confidentiality to see the specific language and details in terms of the exceptions. With regard to attorney-client privilege, accidental disclosure can sometimes lead to a waiver of privilege. Now, the first bulleted item says death of a client in criminal cases under certain circumstances. This would have been the last bulleted item I probably would have highlighted. I think it's a very limited area, and it may vary from state to state. We would have to look to our state's laws and or case law in order to find out if this applies and how so in those very limited circumstances. The most important issue, however, as I just hinted at, is somebody discloses privileged information to a third party other than the attorney. So if the lawyer's team does it intentionally or accidentally, we would hope neither would happen, but it can sometimes accidentally happen. Or if the client shares the information, that sharing of information does not change the element of confidentiality, but it does ruin the attorney-client privilege. So that's a very important distinction to remember. So with our understanding, now let's check our knowledge. So we have a scenario here. We are working for a legal team and we have a corporate client. And through one of the owners of the corporation, they bring to the law office the following pieces of information relating to the representation of the corporation. One, internal reports generated by the company based on company data. We have reports that were collected from state and county officials. And then we have personal knowledge that the client, the owner, has about the operations of the corporation that they gave to us in anticipation of representing us in a legal matter. So which items are covered by confidentiality, which are covered by privilege? Internal reports generated by the company based on company data alone would be covered by what? Both, correct? Everything gets covered under confidentiality, regardless of source, when they bring it to us. The big question here is it privileged? Yes. This is internal generated. This is only known to the company, the corporation, the client. Therefore, it's privileged information. Unless it's being generated in terms of standard operating procedures, that might take it out from there so that it could be requested under discovery tools, for instance. But if it's just company generated data that isn't that may not be seen as a regular creation of the company, then it could be privileged. Reports that were collected from state and county officials, that would be, again, confidential, but it's not privileged because it's coming from third-party sources. Finally, personal knowledge that the client had about the operations of the corporation, again, that would likely be covered by both. It is confidential, covered under confidentiality, all three are, but that would likely be seen as privileged under most circumstances. There may always be exceptions. We would look to the very specifics of a case to determine with greater detail. But if it's known only to the client, then that would also fall under attorney-client privilege. Well, I hope this helps you understand this important concept. If you have any further questions, please reach out to your instructor. Have a great day.